This is English Shorthand Dictation number 295 and the dictation speed is 100 words per minute. Ready? Start. It is my pleasure to join you today for the inauguration of the Rule of Law project. Rule of law is the foundation stone for the efficient functioning of our democracy. Only by following the rule of law can we seek to deliver timely and quality justice, reinforce public confidence in the law, facilitate investments, enable better distributive justice, and promote basic human rights. The preamble to the Constitution identifies securing social, economic, and political justice for all citizens as one of its key objectives. Access to fair, quick, and speedy justice is a constitutional guarantee recognized under Article 14, which lays down the principle of non discrimination by assuring every person of the right to equality before the law and equal protection of laws, and Article 21, which guarantees that no person will be deprived of their life or personal liberty except in accordance with the procedure established by law. It is the responsibility of all organs of the state to ensure that the administration of justice is made easily accessible and affordable for the common man. Yet we find that courts in the country are burdened on account of the large number of cases that are pending before them, often leading to delays in the delivery of justice. The socially and economically weaker sections of society are the ones who suffer the most on this account. Very often, they do not have the capacity or the resources to face prolonged legal disputes, causing them to either forego their rights or settle for less than their due share. One example of this can be seen from the large number of under trial prisoners, many of whom belong to the marginalized sections of the society. Securing the timely release of such persons is an important facet of upholding the rule of law, which is why they have the first right to obtain timely and free legal aid from the state. Article 39A, which falls under the category of directive principles of state policy, speaks directly on this issue. It requires that the legal system should operate in a manner that promotes justice on the basis of equal opportunity, particularly by providing free legal aid so that citizens are not denied the opportunity for securing justice on account of economic or other disabilities. The National Legal Services Authority and state and district legal services authorities have been established for this purpose under the Legal Services Authorities Act 1987 to provide free legal services to the weaker sections of the society. They are also responsible for organizing Lok Adalats for the amicable settlement of disputes in a timely and cost-effective manner. The government is strongly committed to the cause of improving the investment climate in the country, which is the key to overall growth and development of the economy. Recognizing that timely enforcement of commercial contracts is one of the main factors that influence our ranking on the ease of doing business index, the government has accorded a high priority to improving India's performance in this area. Some of the measures being undertaken on priority basis for ensuring timely and effective enforcement of commercial contracts involve exploring the possibility of setting up of specialized fast track courts and tribunals at the subordinate level and specialized commercial divisions at the high courts level to deal with the commercial cases and encouraging arbitration to resolve contractual disputes. This is in addition to the proposals that are being pursued for the adoption of information technology solutions and court and case management systems for handling such cases. The Law Commission of India has recently submitted its 253rd report on Commercial Division and Commercial Appellate Division of High Courts and Commercial Courts Bill 2015, containing their recommendations on speedy disposal of high value commercial suits. The report contains several valuable suggestions that are currently in the process of being examined by the government. Commercial and non-commercial cases alike are affected by the issue of overall delays and pendency of cases in courts. This poses a complex problem that needs to be addressed through a combination of legislative, policy, and administrative measures. We are therefore working towards examining the real reasons for delays in courts, identifying the appropriate solutions, and taking all necessary steps to implement those solutions. There is a shortage of judges and judicial officers, which needs to be addressed through continuous increases in the sanctioned strength of judges and at the same time by filling the existing vacancies in the posts of judges and judicial officers. As a result of concerted efforts made by all stakeholders, the sanctioned strength in district and subordinate courts has increased. As regards high courts, the Chief Justice of India has given in principle concurrence to increase the strength of high court judges by 25% of the existing strength. Despite the gradual increase in the sanctioned strength of judicial officers, there still remain a large number of vacancies in subordinate courts. We have been coordinating with state governments and high courts to address this issue. It has been observed by various expert committees that some state governments are spending a very small part of their total budgetary resources on the judiciary, while the primary responsibility of infrastructure development for the high courts and subordinate courts rests with the state governments. The central government has also been augmenting the resources of state governments under a centrally sponsored scheme for development of infrastructure facilities for the judiciary. The CPC has been amended to introduce several provisions, such as those relating to limiting unnecessary adjournments and imposition of costs for the same, for ensuring that trials in civil cases are concluded in an expeditious manner. However, these provisions are not being strictly adhered to by courts, leading to delays in court proceedings. Proper training and sensitization of judges on these issues can help in achieving better implementation. The indiscriminate use of writ jurisdiction and multiple levels of appeals also leads to delays in the final disposal of cases.